Hi everyone. This is Priya from It's Okay Yaar, and welcome back. We have received a lot of questions about the new H-1B proposed rule. So we have Sonal with us, and if you have been following It's Okay Yaar, Sonal is not new to you. Hi, Sonal.
Hi Priya, how are you?
Good. So as you all know, Sonal is an immigration attorney and she's partnered with us on multiple such topics. The H-1B proposed rule, there's a ton of information out there, but what we're going to try to do in this session is try to break it down for you so that you fully understand what it means for you if you are on an H-1 visa, what it means for you if you're on an F-1 visa, and anything else that you need to know. So without further ado, Sonal, let's begin. First, thank you so much for taking the time on such a short notice to talk and talking to us. I really appreciate it. Sonal, the first thing is just tell us a little bit about the H-1B proposed rule. What's happening? What have we learned so far?
So USCIS has issued this notice of proposed rule, which they are gonna post and then open for public comments. What they are trying to do is it's aimed towards modernization of H-1B program mainly. There are some other proposed initiatives for F1 students as well, but it's mainly for the H-1B program. Now, most of the things, it's not everything is not new in there.
Yeah.
Most of the things are already USCIS policy, which they use in adjudications or which they are following through policy memorandums or which they have, their decisions of policy that has happened in the past through litigation. So now they want to codify what the current interpretation of regulations is, and wherever the regulations are a little ambiguous, they want to explain it, make it more clear, and also propose new changes, which will, in their mind, is going to help H-1B program and reduce the fraudulent petitions and stuff. So
Okay.
that's what we're looking for.
So, okay, Sonal, then let's do this in two parts. Like part one, help us understand the proposals in the H-1B modernization programs that already exist, and we have a little bit of clarification. And as part two, what are the other things that they are looking to address so that the fraudulent parts of H-1B applications that happen kind of get reduced. So first, let's try to understand what already was there on the H-1B program that they're trying to bring more clarity around.
So with H-1B, like what is a specialty occupation? They want to clarify it more. What does it mean for a specialty occupation? Now, there are 4 criteria that you have to meet in order for a position to qualify as a specialty occupation. The way regulations are right now, it reads that you have to meet one of the criteria. What this proposed new rule says is that yes, that's the case, but it's necessary for you to meet one of the criteria. It might not be sufficient though. So they're adding a little bit more authority there for themselves to say, like, yes, just because you're saying one criteria is met, we are still not convinced. We need more information. Where it plays part is like one of the criteria is if employers' requirements for the position are at least a bachelor's degree. Now, out of 4, that's 1. So if employer shows that in the past, I have always hired a software developer with a bachelor's degree at least, then you've met one criteria. They have to go ahead and say, okay, we agree, here it qualifies for specialty occupation. Now that's where they want to push back a little bit more and say, like, for example, in this rule as well, they're saying if you are placed at a third party, it's not the employer who is petitioning the petition, but the third party's education required that will matter. So if a consulting company places you at a JP Morgan Chase as a software developer, they are saying now an employer, if goes back and says that I have always hired software developer with a bachelor's degree, USCI is going to come back and say, we don't care about your requirements. We care what JP Morgan does because he's placed at the third party. Now they've also further clarified what does placed at a third party means. So they have clarified it's in 2 ways. One is when you're staffed to the third party, which is you're just contracted out. They are
Correct.
treating it to be like you're filling a position in the hierarchy of the third party. So
Mhm.
you're going to go and fit in their organizational hierarchy. So their requirements will apply. So that's where, when you go back to that criteria, this part that it is necessary but might not be sufficient, they can come back and say, no, 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 show us the requirement of the end client for education requirements. So these are the tweaks they are trying to make in like specialty occupation, definition. They're also clarifying it's not position, it's the occupation. So when you're entering into an occupation, like say, if it's a lawyer, we all know that lawyer needs a degree. You're not going to become a lawyer. So it's the occupation what it requires, not the particular position. But they're also changing it to a downward stream. So it starts with an occupation, like you say, okay, look at this. Oh, the occupation requires most of the time, normally, usually a bachelor's degree. If that's not the case, because there might be some occupations which not always requires a bachelor's degree, but it might be an industry norm. So if
Okay.
everybody in the industry requires a bachelor's degree, then if not occupation, then you will go to the industry norm. If not industry norm, then you will go to the employer's requirement. Like, hey, I have always been hiring people. This is my company's requirement. If that is not the case, then you go to the specialized requirement of this particular position, that the duties of this position are so unique and specialized that I need at least a bachelor's degree for someone to do this job. So now they are streamlining it, that you start with the occupation, then industry norms, then your requirements, and then the position itself. If you show any of these fit your position in this, that it requires at least a bachelor's degree, that will qualify for a specialty occupation position. So
Okay.
adding more clarity, adding more interpretation to how they are going to adjudicate, and what are the milestones you have to touch to make sure that your petition qualifies.
So
So
earlier, so just so that I fully understand, so earlier the specialized occupation was really on the job that I'm going to do. Now it's going to be all four. Like it starts downstream where you start with the higher level and then ensure that every other criteria is also meeting. Is that?
earlier also it was occupation, but the language in the regulation was position.
Oh, okay. So
So
it's just clarifying.
they want to make sure that everybody is on the same page. We are not talking about this position. When we are
Okay.
talking about entry into when we are talking about H-1B specialty, we are talking about an occupation. We're talking about lawyers as an occupation, architect as an occupation, software developer as an
An
occupation,
occupation, not
not
as a
just
position.
not just this
Okay.
position. But if you have to clarify this position, then that's why there is a downward stream now. It's more clear. You
Okay.
first look at occupation, then industry norm, then employer's requirement, and then specialized position, because there might be a case where, you might not need a bachelor's degree to be, say, a game designer. But this particular project or position is so complex or unique or whatever, that anybody who does not have a bachelor's degree, who did not go to school to learn this, might not be able to do it, and I don't want to take that person. So you will have to basically then create an access between the position and the requirement, to show that it qualifies for specialty occupation. It's already there. They're just clarifying it more.
How? The
There
how
is
of
no
it.
confusion. Yeah, because
Got
the
it.
language in the regulations is kind of overlapping. So they were using position to be meaning as occupation. Now they want to clarify it. It's not the position, it's the occupation we are talking about.
Okay, so on this part, basically, the first one is around clarifying what the specialized occupation means and how it's all defined, the downstream aspect of it. The second one is around what happens if you're working with a third party. It just depends upon who you will be actually working for, who your client is, and what that requirement is. Is there anything else specifically that we're missing?
Yes. So for the third party, there is also clarification, right? They're saying there are two types of situations where you could be providing services for a third client. One is you are contracted out, you go work
Correct.
for the third client. Second is like a lawyers, the attorney works on different client
Right.
projects.
Hmm.
you're also providing services for third party, right? Or a CPA or at a tax attorneys. They
Okay.
also, like PwC has these tax attorneys, they work on clients'
Correct.
projects. That is not same as staffed and contracted out to the third party. So they
Correct.
want to see if it is the latter, like PwC situation, then PwC's bachelor's requirement is the requirement they're going to look at. But if it is the other, where you're staffed to the third party, they are going to look at the third party's education requirement and not your education requirement. Why this is worrisome is because, some of the big companies have officially announced they don't need a bachelor's degree for an IT position anymore,
Okay.
right? How that's going to play out now, it could, because now if Google officially says that we don't need a bachelor's degree for IT positions as a policy, and then they are giving a letter saying we need a bachelor's degree for an IT position, that's kind of contradictory. So by putting emphasis on requirements of the third party and client, it's going to run into problems, because further with the specialty occupation, with the new rule, they also want to codify their authority to ask for client documentation, work orders, SOWs, all of that. Right now, after the litigation, USCIS has no authority to ask for such documents. So they want to put it in the regulation now that by authority through these regulations, they will be able to ask for it. So to prove a non-speculative petition, especially when you're contracted out to the third party, it's going to go back to the Trump era where you have to attach agreements with every party that's involved, SOW, client letters with specific wording in those documents, which will be towards education requirements, duties, all of that. So more paperwork is going to come for the H-1B petitioners, especially for the consulting companies.
Oh, that's super helpful. And I think that part I really understand, where you say that like if you are going to be working through a consultancy on a client project, then we need all of those documents. Can you help me clarify a little bit around the fact that you mentioned that if there is a company X, or like a PwC or a Google that you gave as an example, where if someone is working on a client, then and Google has, or PwC has said that for to do this work, we might not need a bachelor's degree, what happens then? Like, is that like that ambiguous area where we are yet to figure it out, or
No, in that case, they're going to rely on the PwC's requirement.
okay, so it
Because
doesn't.
that's the company who is saying like, hey, look, I need attorneys who is going to work on this client's projects. I need bachelor's degree for all my attorneys. I'm not going to hire anybody who doesn't have a bachelor's degree, or a CPA who doesn't have this. So any company which is like providing services for the third client, but you are actually working with the
With
company,
them.
like in okay, you get a contract from Google, like, hey, can you build this app for us? And then you are building in your office, you have your own team, you build it out, whatever the product is, then you're going to give it to them, like, here, what is built for you. In that situation,
It
employers
is Google.
requirements.
It is just
Yes.
whatever Google's requirement is at that point. If Google is like, we don't need a degree, whatever that is. Okay,
Yes.
got it. Okay.
Yes.
Again, for everyone to clarify, all these examples that we are using as companies is just as examples and references. We don't have any insight into what's happening with these companies. We've just taking examples. So wanted to be very, very clear there. So super helpful there, Sonal. And before we move on to some of the F1 piece, is there anything else that an H-1B employer must know? Like the one question that immediately comes to mind is like, if 4 companies filed my H-1B lottery or application, is that something that can still happen? Or would you say like that is a part 2 piece that we should cover?
Yes, it can happen.
Okay.
So what they are trying to do with lottery system is that now they are going to pick not registrations, but beneficiaries. So right now, what was happening, if 10 people applied for you, 6 could get picked up. Then you have 6 numbers which are going for the same beneficiary.
Oh,
Right?
okay.
6
Correct.
registrations picked up, 6 number picked up. What they're going to do now is only 1 number is going to picked up per beneficiary with your date of birth and passport. That's going to be the combination that they're going to use. Your
Okay.
date of birth and your passport. With that, they're going to select the registration, then inform all the companies who filed for you. And then it's basically beneficiary's choice who he wants to go with.
Oh,
So they are saying that way only one number is picked up instead of 6 earlier. And now beneficiary has more bargaining power to see which
which,
employer I want to work with, because it's a cap petition in the end.
yeah.
So you're only going to be able to file one. So the beneficiary can choose out of these 6 or 10 who filed for me who I want to go with. And that way, they're not going to be multiple filings. They're not going to be multiple. Yes, there are multiple registrations, but in the end, only one is counted. So you still get to file it through 50 people, but in the end, there is only going to be one registration that's going to pick up, and there is going to be one petition that's going to be filed on your behalf. So
That is
that's the difference from earlier.
No, that I feel is like extremely important and a big deal, and especially because they figured out like passport and date of birth is the unique combination, and it gives the beneficiary more bargaining power to then work with those employers, and then it also gives others more chances. Because, for example, if I had like 10 picked up, then 9 of the people are actually suffering, and that doesn't happen anymore. So that's
So
really good. Would you say that?
with a unique beneficiary, it's just going to be one chance. Now you don't
Okay.
have more chances than other.
Yeah,
Everybody has equal chance because it's going to be picked up on
that's
your
perfect.
biometrics information.
Well, that truly feels like the H-1B program is getting modernized, because that was, I think, one of the big reasons why all of these frauds, etc., were happening. Would you agree with that?
Yes, absolutely, absolutely.
Okay.
In the normal H1B situation, there are a couple of more things. Before we move on, I just wanted to touch on that.
Yes.
They are eliminating the employer-employee relationship definition. So right now, as per the regulation, a common law definition used to be followed, which means that to show that you're an employer, you only have to show that you have the authority to hire or fire or pay slip, or so there were like
Yes.
different ways you could show. So they are getting rid of all of that, and they're going to rely on Department of Labor's definition, and also attach it to bona fide job offer. Now, how do you show bona fide job offer? You will have to show that it is a non-speculative petition. So DOL's definition is, if you are eligible to file a petition for somebody, you are an employer. But how you are an employer, USCI is saying we are going to adjudicate it based on whether it's a non-speculative filing based on a bona fide job offer, and they're now tying bona fide job offer to show us the agreement, show us that you have work available, what project they're going to work on, SOWs, work orders, client letters, all of that. So now they're combining it, all of that requirement of non-speculative filing to the definition of employer through bona fide job offer.
Okay, so it is not, they're trying to add more rigor to the employer-employee relationship as well. And like the employer has to really show everything that is available, and not just have like one of those criterias in the beginning that existed around how employer-employee was defined. Is that correct? Like the employer also has to put in the work to be like, this is the exact project, this is how we are going to be working with them, this is the SOW, etc.
So what they're trying to do is to reduce speculative filings. So,
Okay.
okay, I don't have work, but let me just file the H-1B. Once he comes here, I'm going to market him, place him on a job.
Oh, that's
That's what
okay.
they're
That is a
trying to
help.
cut it.
Okay. Okay.
So
Okay. Okay.
show me in the beginning you have work for him. That's how you are going to become an employer. You have work available for this person day one when he lands, and he's going to work on this. So they're tying it to speculative, non-speculative filing and attaching it to bona fide job offer, making it employers responsible, that if you are really an employer, you should have all of this. And if you're filing an H-1B cap petition saying he's going to work on an in-house project, but if you, most of the consultancy are not going to be able to file it, because now they've clearly said, if you do not have a history of developing any product, just your word or like you say,
Yeah.
we are not gonna, that's not gonna be enough.
Yeah. You just can't
So
create that. Okay, this is what I will be working on. You have to show that there is a history, that this is the kind of products we work on if you want to bring them on board, if you don't have an exact project carved out. Okay, that is super helpful. And I think very interesting for like anyone who's filing their H-1B. So thanks for sharing. Anything else on the H-1B before we move on to the next
one
part?
more thing, that right now site visits happen
Mhm.
for H-1Bs, L-1s, all of those cases it happens. But right now it is not mandatory for employers to participate in it. They can participate voluntarily, they can refuse to participate. Now through this regulation, USCIS is codifying it as their authority and making it mandatory for the employers to participate. If the employers do not participate or do not provide documents or information requested, USCIS will have authority to revoke the petition or deny the petition. Right now, it is a voluntary process, but they want to make it a mandatory authority that employers will have to participate, including the third-party clients. So if somebody is placed at, say, third-party client, the third-party client needs to, right now, third-party client JP Morgan Chase, we have a contract. What do they care? USCIS
Yeah,
officers come, I don't have
sure.
time to deal with this, go talk to the employer. Through this, they are saying no. They
Mhm.
will have to talk to us because they are the ones who are working with them. Their education requirements matter. We are going to talk to them. And if they don't participate, we are going to revoke your petition. Now, the problem with that is the business doesn't work like that. So it's
Sure.
just going to be super hard for somebody to place consultants where if they ramp up the site visits and everything. And they're also saying that site visits will also include um, going to the beneficiary's home if LCA
Mhm.
has a remote work location. Remote work location is fine. That's also they want to clarify as long as it's in the US. Telecommute, remote, partially, whatever is fine, as long as it's going to be in the US.
Oh, wow. So basically, like the easier part that a lot of big companies had was like hiring a consultancy, having a lot of folks, or just contracting, and then the actual employer deals with it. That's no longer the case. If you're still hiring, then that will happen. Okay, so that's super helpful. When they say about site visits, have would love to understand a little more. How does that work? Is it like once a year, or is it a one-time thing, or is it very arbitrary? Like, especially because now there are hybrid and remote physicians and they can visit a home. So I'm curious if there is any information available about that.
So right now it is random checking.
Mm-hmm.
Uh, they go to based on the LCA, whatever it says that work location is, they go there, they talk to the employer or beneficiary or both of them separately, together, however they want to do, just to make sure that everything is as per the LCA. So say the LCA says he's a systems analyst, but when they go to the client side and ask his manager, what does this person say? They say, oh, he's a developer. Now, software developer salary is higher than a systems analyst, but the employer has put systems analyst on LCA to pay lower salary, whereas he's actually working as a software developer. So that's what they want to make sure, that everything is lining up. You're not gaming the system. The employer is paying the right wage and everything, what they have said in the petition. Because yes, you have given us all these paperwork, but what he's actually doing at work, we don't know. So we want to make sure everything aligns up. Now, what they are trying to do here with the regulation is that participation is going to be mandatory. Now, if you do not say provide this information, then right now what happens is the officer says, I went there, they did not talk to me. I sent an email, they didn't respond to my email. Here is my report. I don't have anything because I could not verify anything. USCIS cannot go ahead and revoke the petition based on that because it's a voluntary program. What they're trying to do now is if you do not
Yeah.
participate, we are going to revoke your petition because we don't trust that the petition was right in the first place. So that's worrisome
Yeah.
because sometimes the officers, they are not lawyers, they are not, trained. Say they don't understand completely, and then you are stuck if they write a wrong report or if they are confused about something and wrote something bad in the report back to the USCIS, and USCIS sends you a notice of denial or notice of intent to revoke, then you are litigating that. So that's going
Yeah.
to be, I think, in the comments, we're going to see a lot of pushback there.
Okay. That super helpful. Last one there is, do you expect this for just new H-1B applications starting next year, or like the current ones that are already active? Like, what does that mean?
So it's going to apply to everything. H-1B petition as long as it's codified, right? Once it notice period is over, as soon as it becomes effective, it's going to apply to everything. With registration process, like how they're going to
Yes.
calculate or pick up,
Next.
that might get delayed because they might not have enough time to implement it in the coming year. They might implement it next year, depending on whether they're ready or not. But they might be ready this year as well. We never know if it goes through before that. But that is the only part where they've specifically said in the regulations that might get delayed. Everything else will be effective as soon as it comes into play.
When do you expect this to happen? Do you have a sense, like in the next 1 month, 2 months, 4 months?
So it's going to be posted today, I think 23rd October, and then there is a 60-day comment period when it's going to open for public comments. Once they receive the comments and it's closed for public comment, then they generally take about 60 days after that, or maybe 30 days, depending on what kind of comments they have gotten, because they have to respond to all the comments as well. They have to go through all the comments and take into consideration, might change position on some things, they might not change position on something. If they are changing position, they will tell why they are changing position. Then they are not changing position despite having these comments from public, and then they will publish. So realistically, it could go as soon as March 1 or later than that as well.
Got it. Okay. Super helpful. I hope we've covered everything about the H-1B. And then we have two more that we definitely want to talk about. One is the F1. What does it mean for that? And what does it mean for H-1B gap exempt? So let's start with what does it mean for the F1 students?
So F1 students right now, if their work authorization ends before October 1, and they have filed their petition before it expires, like either it is OPT or STEM OPT, say your OPT is expiring on April 30th, and you filed your H-1B petition April 15th. Right now you get cap gap, which means your work authorization and your F1 student status is automatically extended until October 1. If your H-1B petition is not approved by them, then you need to stop working on September 30th. You can stay here, but you need to stop working. What this regulation is proposing to do is to extend that cap gap to April 1. So give you another 6 months of work authorization. Because right now, most of the times, petition is not getting approved before October 1. And if you are in the second lottery, say somebody's OPT was expiring in September 15th, and they filed on the second lottery, which is open until October 31st, it will be beneficial for them also. In the earlier time, they had to stop no matter what, because cap gap is only applicable until September 30th. Right now, they'll be able to work at least until March 31st. If the petition is not approved by March 31st, then their 60-day grace period will start and won't be able to work during that period. So basically, if you still do not get approval until March 31st, you should upgrade it to premium as soon as possible. That would be the only way. But in USCIS perspective, they should be able to approve all the petitions, cap petitions, by March 31st, especially if you are on F1 status. There was a point a few years ago where they asked us to mention on the filing that this is a cap case so that they can prioritize it. They used to do that in past. So they probably are going to do the same thing, that prioritize the cap cases so that there is no hindrance in the employment. It's either April or the approval of the petition. So if your petition gets approved on January 15th, then that's it. You're on H-1B from January. Otherwise, it will go up to March 31st.
Okay, got it. So this is good news because now they're trying to extend that, and that did not exist. So super helpful. Is that the only thing for the F1 students that they should be aware of?
Yes, that's the only thing.
Perfect. Can you shed some light on the H-1B cap exempt and what does it mean for them?
So what they're trying to do with cap exempt is they're changing language a little bit in the regulations so that it is much easier for more entities to qualify as a cap exempt employer. So how the regulations are framed right now, it says that if you are like a research organization or government research organization, research has to be your primary mission. What that does is that restricts the entities that can qualify, because if you're not, if as an entity or a non-profit organization or a research is a part of your organization but may not be the primary mission, then you don't qualify as a cap exempt employer. So what they are doing is changing it to fundamental activity instead of primary mission, primary. They're changing it to fundamental activity, which means that if as a non-profit organization, if you have 4 other things going on, one of them will qualify as a cap exempt employer. So the example they have given is like a non-profit organization which participates in eradication of malaria, but through lobbying, through awareness, and they also do research. They can qualify as a non-exempt organization. So they're expanding, saying that it has to be still important and substantial function as a fundamental activity of the organization, but it doesn't have to be the primary mission or primary function. And for that matter, there was also a requirement that the beneficiary who is working there, his duties directly needs to be related to the primary function. So now they're also changing. So if somebody is like in IT, say in a Mayo Clinic, right? It's very hard to say somebody working in an IT with Mayo Clinic is objective. But under this new, they're changing it that nexus, as long as the duties goes towards the fundamental activity, that's good enough. So a hospital can say digitization is important for us.
Yeah.
Right. So now you are achieving that fundamental activity. So more entities can, participate.
The H-1B cap exempt. So that's also a good news that earlier it was just the primary piece. Now it needs to be a substantial aspect of what you're trying to do. So super helpful. That's also positive. Anything else on H-1B cap exempt that we need to talk about?
Yes. So they're saying that under regulation, it is allowed for you to work for a non-cap exempt entity and a non-cap exempt entity at the same time. It's allowed. So if you are employed with a cap exempt employer, you can also work for a non-cap exempt employer without going through lottery. So what they're trying to do right now is that earlier the language was that majority of your time has to be with the cap exempt employer. Right now they are changing it to 50%. So as long as you devote 50% of your time and your duties with cap exempt employer, you're okay to go 50% of the time with a non-cap exempt employer as well. So again, if you're not directly employed with an entity who is, doing or cap exempt, but 50% of the time you are working with a cap exempt employer, it's still going to be okay for you.
So you can have one cap exempt employer and then find a different employer that is not cap exempt as well. When you find a different employer that's non-cap exempt, will you have to go through lottery, or is that not the case?
As long as you continue working at least 50% of the time with the one.
And then
so it's already there in the regulations. They are just saying from majority of the time, now they have made it 50%. So from majority of the time used to be like more than 50%, right? So now they're bringing it down to 50%. At least 50% of the time, if you're working with a cap exempt employer, you're okay to work with non-cap exempt employer as well.
So this already existed. They're just making it
more approachable.
Okay, got it. So we discussed about the H-1B, we discussed about F1, we discussed about H-1B cap exempt, but more importantly, we discussed how this will reduce the fraudulent applications for H-1B program. So I think that was helpful. Is there anything specific that we haven't touched on that people must know about?
Yes, very important. So people who own their own companies will be able to file their own H-1Bs. This is huge. So if a person, right now, the problem is the employer-employee relationship. So if you are owner of your own company, then there is no employer-employee relationship because there is no distinction between you and the company. So now with the employer-employee relationship practically gone, and USCIS wants to promote new companies, innovation, blah, blah. So they're saying that it's okay for you to be a controlling member of a company and file for your own H-1B, as long as at least 50% of the time you're going to do the specialty occupation position duties. So what the concern was that if you are your own employer, if H-1B is filed for you, it has to be filed for a specialty occupation position, right? Now, say if you are chief technology officer, SOC used is computer system information manager. Now, that's your role. But as an owner, you also have to run the company.
Other things.
You're also going to do some jobs which are beyond
Not.
purview of that SOC code. So now they're saying as long as you do 50% of those, you're okay to run your business as well. You will be able to business development, signing contracts, signing leases, be the signing authority for the company,
You
going
can
and
do all of it.
as long as you're going to do 50% of the time the specialty
Special.
occupation duties that the petition is filed for. So if you are like software developer for the company because you are the one who is coding for the app, then as long as you do that for at least 50% of your time, you are okay to own your company, run your company. Earlier you used to have a board because
Correct.
otherwise
Correct.
no employee relationship. Now that requirement will be there as long as you can show that you're going to work in that specialty occupation petition duties for at least 50% of the time. But it's going to come with some reasonable conditions, and those reasonable conditions are, first of all, you will have to thoroughly explain how you're going to do 50% of the time, right? That's going to be a task to show that at least 50% of the time you're doing the duties. So that's there. But other than that, they are going to give you the first petition and the first extension after that for only 18 months at a time, not
Okay.
3 years. So they're going to divide it up. First time you apply, they're going to give you 18 months. And then first extension you apply, they're going to give you 18 months. And after that, it could be for 3 years. What they're trying to do is like, yes, not everybody should be able to just file it and again use the system. They want to, discourage frivolous filings where people don't use like, oh, I opened the company and then, tech company, but then you're running a restaurant on the side. They don't want those things to be happen. So they're going to scrutinize this, but they are openly saying it will be much easier. It's possible for you to now apply for an H-1B through your own company. You can also work for multiple companies at the same time, which you own. That's also going to be okay. So you can concurrently work for 2 companies and you could be owning both of them as long as you meet the criteria, what they're asking you, that at least 50% of your time you're going to do the specialty occupation job duties, you should be able to apply for yourself.
Okay, so they're encouraging entrepreneurship with H-1B. That's very, very clear. When you say, I have 2 questions basically. So if I have my own LLC, I can basically, as long as I can show that 50% is specialized, I should be able to do that. My
Yes.
question is, if I am owning multiple such LLCs and I'm doing that, does that require me to go through concurrent H-1B before I can do
Yes.
that? Yes. Okay.
Yes.
So that's helpful.
concurrent H-1B with multiple of your companies, or like you right now also you can do concurrent H-1Bs. You can do multiple jobs.
Yeah, correct.
But they're saying that it's okay for you to be a concurrent employee with your own companies if you have multiple companies. As long as you will meet this criteria, you should be fine and you should be able to do it.
Got it. And I'll ask the last question, but for anyone who doesn't know what a concurrent H-1B is, we'll link that. So definitely check it out so that you understand how it works. My last question is, if I am going through that route, then can I file my own I-140 on an H-1B visa if I'm going through this entrepreneurship?
Well, again, that's something I think we'll need more clarification on because that's Department of Labor, the PERM process.
Okay.
You still do the NIW and all those because those are self-petition, right? EB-1A. But whether you can do a PERM through your own company, that's something Department of Labor, because there you have to do a good faith recruitment to check the labor market. So I think that's going to be a little contradictory. We don't have that. There's going to be audit though. Even if you have interest in the company, we do PERMs where people have interest in the company, like, if it's your grandfather's company and you just inherit, say, 20% of the company being
Yeah.
grandfather, your grandfather. We do perms for such people, but there is always an audit that comes, which says like, hey, show us that this was a good faith recruitment. Like who takes the
Good.
decision? Who is in charge of? Like they want to make sure that you are not yourself,
Yeah.
advertising and then rejecting candidates and all. But in this case, where you are, say, 100% owner of your company, H-1B is possible. I'm not sure if that's going to be possible for a perm. You might have to come in with the board and change something because that's Department of Labor regulations.
So super helpful. We're unclear on the perm I-140 process, but you can still explore EB-1A or NIW. Again, if you don't know what these are, they're available on our channel. We have discussed this, and I will link that in the description so that you can check it out. But Sonal, that was super helpful. I do have one question, but before that, is there anything else that we must know that I haven't asked or we haven't covered about the H-1B modernization program or the new rule that's out there?
No, I think we have touched. There is slight little thing that related to amendment petitions. So you have to file an H-1B amendment right now whenever the geographical location changes or there is a material change in the position. Now USC is going to codify it. Right now it is on the policy basis. There was a decision which USCIS adopted similar solutions. Now they're going to codify it, put it in the regulation itself that you have to amend in these circumstances, but also added thing that they want to clarify is that maintenance of status is important for amendment petitions as well. It's already there whenever we file an H-1B petition for somebody who is already in the US, whether it is amendment, whether it is extension, we always attach documents to show that this person is maintaining their current status. They want to codify it and put it that it's important for people used to think that maybe their thinking is that it's not clear that it's only required for extension petitions because you're asking for extension of status, but now they want
Correct.
to clarify, even when you're filing an amendment petition, we still would like to see that the person is maintaining their current status.
Correct.
So you could attach different kind of documents, tax returns, again, work order to show this is the project they were working on. So I think they're tightening more on the documentation, again, going back, tying everything back to speculative filings, just to make sure that the current petition. And also one more thing is there that they have a deference policy, which means that if you already have an H-1B approved and you file an extension, they're required to give deference to their previous adjudication. Now they're codifying it, but they're also saying that if the earlier one was erroneous, then we don't have to do that. We don't have to give you deference. So just because we approved something in past, this
Doesn't
policy
mean
does not mean that blindly we are just going to approve the next one as well. You still need to make sure that you meet all the criteria. And if earlier one was not, so if somebody did not attach maintenance status document earlier, we are not going to just give deference to that and approve the next one. We are going to ask you for maintenance of status documents in this petition and not just give deference to the earlier approval.
Okay,
Pretty much
super.
that's it.
Yeah. Okay, super helpful. I think this was a very insightful conversation. And for everyone, like we did not end up covering the two parts of how it worked, but in this video, we ended up covering all about what is it on the H-1B program that you must know. How are they going to find applications so that multiple registrations can be tracked to a single individual? How does that reduce fraud? What does it mean for you if you're on H-1B? We also discussed what it means for you if you are on F1, what it means for H-1B cap exempt, how it's helping entrepreneurship on H-1B as well. So thank you so much. I think that was a lot, and I truly feel it's the right step in the modernization of H-1B program. Definitely a lot of gray area around how the third party relationship or like the consultancies that hire you, how would that work? How would site visitation work? So more to come there. And we expect all of this to come to life after they posted today 60 days of comments, and then so hopefully somewhere next year in March. And that's a rough timeline that we discussed here. So thank you so much, Sonal. The last question to
Before we leave, I just want to let you know that we have an update on the pilot program for the H-1B
okay.
stampings in the US. Officially, they have released that it's going to start early 2024. 20,000 applicants will be eligible. So they're capping it at 20,000 applicants. Early 2024, 20,000 applicants. India will be allowed. as a participant.
Yay.
Earlier, there was a little bit of rumor that it might not, but it will be. And I think it's only going to be applicable for the principal applicants, not for the family. So 20,000 does not include you and your family. It only includes you as an H-1B
You.
applicant. So you will be able to get your H-1B visa stamped in the US. And the last one is that I think there is going to be a requirement that you need to qualify for interview waiver. So if you to qualify, then you will be eligible to apply for H-1B stamping in the US. It's going to come early 2024, and that's all we know. But that's the update we have.
Okay, that was one of my questions. So, Sonal, if you could one more time, because this is excellent news, when do you think H-1B stamping is going to start in the US? If you could give us that date and tell us a little more, that would be awesome.
Sure. So DOS announced that it's going to be live in early 2024. India is going to be participant. Indians, nationals are going to be eligible for H-1B stamping in the US. Principal applicants only, not the derivatives and family. And you have to be eligible for interview waiver process, and 20,000 applicants in the pilot program. And if that goes well, they are very positive to make it a permanent and expand it further.
Okay, awesome. This was super insightful. And the one question that I did get after the H-1B modernization, if we come back to it for a second, do you expect this to expand to L1 as well, or any other visa categories? Does it mean anything for any other visa categories at all at this point?
Not really, because it's specifically for H1, like specialty occupation. These things do not apply to L1.
Generally.
So it's generally, yeah. So it's towards the H-1B program only.
Okay, awesome.
At least the things they are tackling in this proposed rule
Proposal.
are applicable to H-1Bs and F1 little bit, because it's also related to their cap petition. So they're adding that little bit of leverage there.
Okay, awesome. No, thank you so much, Sonal. For everyone who's watching, I hope this clarifies everything that you must know about the H-1B modernization program. Sonal also posts a lot of content on LinkedIn, so I recommend giving her a follow there so that you get updated on anything that's happening from a immigration news perspective. We'll leave her contact details in the description box. Again, this is not a paid promotion or anything by any chance. Sonal definitely puts in the time to share this information with us, and we want to make sure that we bring those resources to you. So thank you again for watching. Please leave comments if you have any. We would love to hear from you. Please like, share, and subscribe if you have watched this video and gotten value from it. And thank you again, Sonal, for joining and taking out an important hour early Monday morning. We truly appreciate it, and really, really thankful for all the partnership with It's Okay, Yaar.
Thank you for having me. Happy to be here. Have a good week.
Okay. Okay, awesome.